Requirements to transfer real estate to an heir. If you're the personal representative of an estate, or you're expecting to inherit real estate from a loved one of the most important questions you'll face is, how do we actually get the property transferred into the right name? And the answer isn't as simple as most people expect. It depends on how the property was titled, what the will says, the value of the estate, and sometimes how much time has passed since the date of death. Get it wrong, and it can be costly. Stick with me. I'm going to walk you through all of it. There's no one-size-fits-all answer here. Every estate is a little different, which is exactly why working with an experienced probate real estate broker and qualified probate attorney is so important. But understanding the framework puts you in the much better position from the start. I'm Terry Peterson with St. Louis Family Resources. I talk with people every day, just like you, that are managing an estate, probate, or exploring senior transitions. I open my Rolodex of service providers, contractors, and professionals I've amassed over the past 20 years to help our clients meet their obligations in managing the estate. I invite you to reach out to me via text, phone, or email. Now back to the video. Factor number 1, how was the property titled? The single most important factor in determining how real estate transfers is how the title was held at the time of death. This one fact determines everything that follows. Held solely in the decedent's name, probate is required. The property cannot be transferred without court involvement. Joint tenancy with the right of survivorship. The property passes automatically to the surviving joint owner upon death without probate. A death certificate is recorded with the county recorder of deeds to clear the title. Tenancy by entirety, available only to married couples in Missouri. Similar to joint tenancy, the surviving spouse takes full ownership automatically, no probate required. Tenancy in common. Each owner holds a separate divisible share. The decedent's share does not pass automatically to the co-owner. It goes through probate and passes to heirs or beneficiaries. Held in a revocable living trust. Probate is avoided entirely. The successor trustee transfers the property directly to the trust beneficiaries according to the trust agreement. Transfer on death, beneficiary deed in place. The property passes directly to the named beneficiary upon death outside of probate. The beneficiary records an affidavit and a certified death certificate with the county recorder to complete the transfer. Factor number 2, what does the will say? If a will exists and the property must go through probate, the next question is, what does the will direct with respect to this specific property? If the property is specifically devised, meaning the will names a particular person to receive it, it passes to that individual once the probate process is complete and the court approves the transfer. If the property is part of the residuary estate rather than a specific bequest, it may need to be sold to pay debts or divided among multiple beneficiaries. If there's no will, the property passes under Missouri's intestate succession laws, and the court appoints an administrator to oversee the transfer. In either case, the personal representative cannot transfer the property until all debts and creditor claims have been addressed. Factor number 3, is the will contested? If the will is being challenged by an heir or interested party, all property transfers are effectively on hold until the contest is resolved. A contested will can add significant time and legal expenses to the process. This is another reason why clear, professionally drafted estate planning documents are so valuable. They reduce the likelihood of disputes arising in the first place. Factor number 4, debts, liens, and creditor claim period. Under Missouri law, creditors have 6 months from the date of the first published notice to file claims against the estate. Generally speaking, real estate cannot be distributed to an heir until that window has closed and all valid debts, taxes, and estate expenses have been satisfied. If the estate does not have sufficient liquid assets to cover its debts, the personal representative may be authorized to sell real estate to satisfy those obligations, even if the will directed that the property go to a specific beneficiary. It's also important to check for any existing liens against the property, mortgages, mechanics liens, or Medicaid estate recovery claims through the Missouri Health Net. An heir who receives a property with a lien inherits that lien along with it. Factor number 5, the transfer method depends on the estate value and timing. Missouri law provides 4 distinct pathways for transferring real estate out of the estate, depending on the size of the estate and when you're initiating the process. Full probate administration, required when the estate exceeds $40,000 and the transfer is initiated within 1 year of death. The personal representative receives authority through letters testamentary or letters of administration and executes a personal representative's deed to transfer the property. This process typically takes 9 to 12 months. A small estate affidavit, available when the total estate value is $40,000 or less. A simplified court process with no formal hearings, typically completed in 6 to 10 weeks. Determination of heirship, used when 1 year has passed since the death and no probate was previously opened. Involves a brief court hearing and typically takes 7 to 10 weeks. Affidavit of heirship, an out-of-court option available when real estate is the primary remaining asset. More than 1 year has passed and the heirship is undisputed. This is the fastest and least expensive method, though some mortgage companies and title companies may not accept it. The personal representative's deed. In a standard probate transfer, real estate is conveyed through a personal representative's deed, a specific type of fiduciary instrument that is distinct from a standard warranty deed. It is named for the role of the grantor, and it conveys whatever interest the estate holds in the property to the heir, beneficiary, or third-party buyer. A few critical points about this deed. It must be prepared by a licensed probate attorney. Many title companies in Missouri will not prepare a personal representative's deed. The personal representative must have a certified copy of letters testamentary or letters of administration to sign the deed. These letters establish their legal authority to act on behalf of the estate. The deed must be signed by the personal representative in their fiduciary capacity, notarized and recorded with the recorder of deeds in the county where the property is located. Supporting documents, including a certified copy of the death certificate and, if applicable, a copy of the will, must also be recorded. In supervised administration, a court order approving the specific transfer is typically required. In independent administration, the personal representative may have authority to transfer under the will's power of sale without separate court order. Now, the stepped up basis. A major tax benefit for heirs. Here's something that every heir receiving real estate should understand. And it's one of the most significant financial benefits of inheriting property rather than receiving it as a gift. When you inherit real estate, your cost basis in that property is stepped up to the fair market value of the property on the date of the owner's death, not the original purchase price. This matters enormously when it comes to capital gains taxes if you later decide to sell. Here's a simple example. Say the decedent purchased a home for $80,000 30 years ago, and it's worth $280,000 at the time of death. If you had received the home as a gift during the owner's lifetime, your basis would be $80,000, and a future sale at $280,000 would trigger capital gains taxes on $200,000 of gain. But because you inherited it, your stepped up basis is $280,000. If you sell it shortly after inheriting it or near the value, your capital gains is zero and you owe zero capital gains tax. This is why establishing the fair market value of the property at death is so important, and why your probate attorney and an experienced real estate broker should be involved early in the process. Your broker can provide a comparative market analysis to help document that value for the court and for tax purposes. Check out an in-depth video on the step up in basis on our YouTube channel. There's much more to be discussed. Fair market value at the time of death. Missouri courts require an appraisal or documented value of real estate as part of the estate inventory. This establishes the value of the property for the court and tax purposes. As your probate real estate broker, I can provide a professional market analysis to support that valuation and also give you a side-by-side picture of the property's current as-is value, its value with basic repairs, and its value with a full renovation. That gives the personal representatives and beneficiaries the information they need to make sound decisions. Work with the right professionals. Transferring real estate from an estate to an heir is not a do-it-yourself project. This combination of probate law, title requirements, and tax implications means that mistakes can be expensive and sometimes irreversible. You need a qualified probate attorney to prepare the deed and navigate the court process, and an experienced probate real estate broker to guide you on the property itself. If you have not yet engaged an attorney, please reach out to us. We maintain a network of probate attorneys, accountants, and other professionals that we and our clients have worked with and trust. We're happy to provide a referral. I hope this gives you a much clearer picture of what's involved in transferring real estate from an estate to an heir. As always, every situation's a little different, and that's exactly why we're here. Check out our YouTube channel for additional videos on each of these topics in more detail, and visit our website for a full library of probate resources. Please feel free to reach out with any questions. I'm here to help guide you and your family every step of the way. I'm Terry Peterson, and we have a wealth of additional helpful resources on our website, stlouisfamilyresources.com. We look forward to assisting you and your family. Thanks so much for watching, and we'll see you in the next video.